The Supreme Court today ruled against Amazon warehouse workers who argued that they should be paid for the extra time it takes them to be screened at the end of the workday. Cases like this are often argued by a relatively tight circle of lawyers who are well known to the justices and are more likely to share the same education and private firm pedigrees. Reuters looked at 17,000 petitions filed with the court to try to put numbers to that conclusion and uncovered an unusually insular legal world at work at the nation's top court. Reuters legal editor Joan Piscopo joins us to detail the findings. Joan, start by telling us exactly what does it take to become a lawyer who argues at the court?
Well, you could be admitted to the Supreme Court bar just by virtue of being a lawyer anywhere out in the country. But for this tight group, it's these repeat performers. They're people who've come up mostly as perhaps Supreme Court law clerks themselves, worked behind the scenes, worked for the prestigious office of the Solicitor General. Those are the people who are dominating now. But generally speaking, anyone who is a lawyer who's admitted to the Supreme Court bar, which literally would cover thousands, tens of thousands out in America, can argue. It's just that what we found is that more and more clients are turning to this select group, and the justices themselves seem to be signaling that they're interested not just in the merits of a case that's presented to them, but the merits of the lawyering, just because of what the data have shown.
So you narrowed it down literally to the elite 8.
Oh, yes, in terms of people who argue. In terms of people who are very successful getting their petitions heard, we went from 17,000 to 66. But then we went to these big 8 before the big 9. People who, get this, Gwen, over the last decade, these 8 had 20% of the cases. In the previous decade, it took 30 lawyers to have 20% of the cases. That's how much it's contracted.
Now, it's probably anybody who follows the court assumes there's a unique group of people who have risen to the level where they can argue before the Supreme Court, and it's not terribly surprising. But is there something, is it a self-fulfilling prophecy, which is if you find somebody who knows how to argue before the court, they are more likely to get hired?
I think so. And what we found is that it's very reinforcing. The justices look for the people who are getting the cases are people who've been there before. They advertise their numbers on their websites. They pitch themselves to clients that way. In fact, Paul Clement, who won the case that you referred to at the outset, that was his 75th argument before the court.
Wow.
And what he has in common with this narrow core is that he had been a Supreme Court law clerk to Justice Scalia and that he had been U.S. Solicitor General. Now, of our 66, I think 25 had worked in the Solicitor General's office.
So what harm does that do to have the people who are the most experienced do the most work?
It's not just that they're the most experienced, it's that they have corporate identifications. Of the 66 who are most successful at getting their petitions accepted, 51 had ties to corporate America. And if you're in a corporate law firm, you're going to represent big business, and you will have conflicts of interest not to represent individuals, employees with grievances, consumers, for example.
When the justices sit on the bench and look out at these folks arguing before them, do they see themselves pretty much?
In some ways. You know, Chief Justice John Roberts was once a member of the Star Appellate Bar. He had argued 39 cases before the justices, and several people who appear before him are kind of models of him. In fact, they want to be models of him.
Now, you talked to 8 of the 9 justices about this. Did they say, yeah, it's a problem, we wish you could fix it, or they see no problem whatsoever?
No. In fact, what they say, I went to the more liberal justices first, thinking that maybe they'd be a little concerned about the lack of diversity, broad diversity before them. And they weren't. They said, what we want are experienced counsel. That's what really matters to us. And they said, you know, look, the corporate tilt could be countered by lawyers who might represent, be in the law school clinics and help out for individuals. But then when we talked to the people in the law school clinics, they said, you know, we can only do so much. And
well, that's the question. For instance, you talk about the case that Paul Clement won today. Workers, labor on the other side of it, do they have access also to attorneys who represent those kinds of interests against the corporate interests? Or is it a fair fight?
Well, do you know that labor, as a matter of fact, this year for the first time went to an outside counsel in some way, in a case that was argued earlier this year, in part, I think, because of this trend, thinking, let's not just stick with people in the trenches. Let's maybe go to lawyers who might speak the language of the justices. But then that could disproportionately favor, again, certain lawyers and certain clients.
So when you say it's a corporate tilt, is it a corporate tilt because of who they represent or because of the nature of the law firms they come from?
Both. Now, first of all, I want to say that certainly the predilections of the Roberts Court have been documented as, you know, in some ways favoring corporate America, so it's kind of reinforcing that way. It's that they come from corporate law firms. So they're bound to be representing more big business than the little guy, so to speak, employees. As I said, 51 of the 66 were from there. So you have that, and then again, they would be precluded. These more familiar lawyers who would be sort of more on the justice's radar screen would not be able to take the other kinds of cases.
Is it a vicious circle? And does anybody even want to break it? I mean, does anybody see this as a problem enough to reform it in any way?
Well, this is critics. Remember Michael Luttig? He was a judge on the Fourth Circuit. A lot of people knew of him. He's now general counsel at Boeing. And he is a former Supreme Court law clerk. And he said, what we have is a very narrow conversation going on now with a lot of elite lawyers appearing before elite judges and kind of just not having the broadest policy discussion that would be more helpful to America.
It's a very interesting way of looking at the court. Joan Biskupic, thanks for taking this look.
Thanks, Gwen.